Issue number one, which is on the ballot for people of Arkansas to vote upon next month. And I'd like to ask Joyce Hale from the League of Women Voters to come up and say a few words, please.
Thank you very much for the opportunity to be here. We always are proud to bring services on voter registration. And everyone is looking at some last-minute challenges here, so I hope that you're checking your registration and ready to be an active participant of our citizenry. The League of Women Voters of Washington County is a nonpartisan political organization. We are a multi-issue organization whose mission is to encourage the informed and active participation of citizens in the government and to influence public policy through education and advocacy. After achieving passage of the 19th Amendment giving women the right to vote, this organization was established to prepare informed voters. It isn't much good if you vote and you don't know what you're voting for. We are looking forward to celebrating our 100th anniversary in 2020. Today's increased interest in voter participation brings with it the responsibility to learn about the issues. Tonight's program is one of several opportunities to learn about the issues that will be on the November ballot. The League of Women Voters of Washington County is also offering an opportunity to learn about the ballot issues, and we will be covering all of them, which is a very full plate. Our program will be Thursday, October the 11th, 6 to 8 o'clock at the beautiful new Don Tyson Center of Agricultural Sciences Auditorium. So if you want to hear an additional amount on the issues and certainly covering all of them, we particularly invite you to that event. The League of Women Voters appreciates this invitation to be here to assist with last-minute voter registration, and Tuesday, October 9th, is the deadline to be registered in this upcoming election. We are happy to help you check your registration status, register for the first time, update your record, or answer information about the process. Make sure that you know about the voter ID laws. We have been asked about the starting of a League of Women Voters in Benton County. We would love very much to expand this type of activity. And if you are interested in seeing something like that develop, I have a sheet at the table that I would like you to sign your name. Once there is a critical mass of enough people that it looks like we should get together, the Washington County group would be very pleased to help mentor an activity here. I would also like to make sure that you pass the table to see the information on some of our handouts. We have one that is called Make Your Vote Count, and on it you will have our website, which we are very actively posting many events and information. So please learn about the League. Even though we're in County, we take a very regional perspective. And take one of the cards to make sure that you have the information to check your voter registration. Thank you very much for being here this evening.
Thank you, Joyce. Let me introduce our three panelists for tonight. Joyce, you took my little piece of paper. You took my little piece of paper. That's all right.
I'm always cleaning
That's
up.
okay. I appreciate you cleaning up. Appreciate it. So our first panelist is Representative Janet De La Rosa. She is a graduate of the University of Arkansas. She resides in Benton County, and she is finishing her second term in the General Assembly. Our second panelist is Chad Gallagher. Chad is from DeQueen and was the mayor of DeQueen at one point early in his life, apparently, and has worked with Governor Huckabee at the state level and on national campaigns. He is now a political consultant in Little Rock. And third, we have Representative Jimmy Gasaway. He is from Faribault, and we appreciate you coming over here tonight. He is a graduate of the law school in Little Rock, and he is finishing his first term in the State House. So Representative De La Rosa, we're going to start with you, and you can take as much time as you like to talk about issue 1.
You told me earlier I was just going to get to talk. You didn't tell me how to talk about issue 1 specifically. I was going to get a good 5 to 10 minute campaign speech in here. I'm Janet De La Rosa. I'm from this area. I represent south part of Rogers to the north part of Springdale, so south central part of Benton County. So you are almost in my district right this minute. NMAC is one of the schools that services my district, though, so I consider this part of my district, even though it's not technically located in there. I am serving my second term in the House. I am not an attorney, so probably out of everybody sitting at this table, I'm probably the least knowledgeable on the technicalities of this particular issue. But I was asked to be on this panel just to give the perspective of a legislator and why I personally voted against this measure. Several reasons for it. Probably first and foremost is the legislative power, the power that it would give the legislative branch over the judicial branch. It's a separation of powers issue for me, so that was a no-go right there. But then you start adding in more negative effects, and that is, I think that the ultimate result of this issue, if it were to pass, would be it would still allow the average everyday person to file a civil lawsuit, but good luck finding a lawyer. So technically your civil rights would still be maintained, but practically they would not. And I don't think that that's in the best interest of the people of my district. So that's why I voted against this particular measure.
Thank you. Chad?
Many years in the governor's office and also working as a consultant. And there have been people I wouldn't want to sit at the table with. And these are folks I'm proud to sit at the table with. I tell you, as a longtime conservative, that's the viewpoint that I bring. Issue 1 gives me extraordinary pause, and I'm proud to stand along people like Rose Mims from Arkansas Right to Life and Jerry Cox from Arkansas Family Council to oppose issue 1. Because what issue 1 does is it puts a one-size-fits-all arbitrary value and cap on human life and the suffering of individuals. And there's a lot of reasons to be against issue 1. Representative De La Rosa just spoke on the legislative rules, which I imagine we'll get into more later. That's a big deal. There's a lot of reasons that that's troubling. But for me, fundamentally, the most important reason that I signed up and devoted my energy and efforts to help defeat issue 1 is because it puts in our state constitution a one-size-fits-all dollar amount, that if you lose a limb, if you lose 2 limbs, if you lose your life, no matter the circumstance, no matter the situation, it's the same cap for everyone in every circumstance. And to me, that's going to hurt a lot of real Arkansas families, particularly the most vulnerable amongst us, children, the disabled, nursing home patients, stay-at-home moms who don't have economic value. I'm sure we'll talk more about those various aspects of the bill later tonight. But issue 1 is dangerous for Arkansas because it devalues human life in Arkansas.
Thank you. That's right.
Thank you. As Professor Brill said, I'm Jimmy Gazaway, State Representative from Paragould. I'm a little under the weather, and so please excuse my voice tonight, but I am an attorney. I spent almost 9 years as a deputy prosecuting attorney in Poinsett County, Arkansas. This is my 12th year of law practice. I've also represented municipalities, and I've had a private law practice where I've represented individuals and every kind of case that you can imagine, from family law to formation of corporations and LLCs, wills and trusts, and personal injury cases. And so I do have some experience actually representing people who have been injured, some of those folks severely injured, and I recognize exactly how this issue, if passed and it becomes part of our Constitution, will impact everyday Arkansans. And ultimately, that's what troubles me the most about this amendment, is the impact that it will have on everyday people in Arkansas. Because I believe that it is designed to prevent access to the courts, to deny people adequate compensation for when they have been severely injured or killed due to the negligence of others, and to, again, prohibit access to the courts and to protect the wealthy and the powerful by giving the legislature the opportunity to control the rules of evidence and procedure for our court system. And if the legislature can control the rules, then they can rig the system in favor of the wealthy and the powerful so that the everyday Arkansan will not be able to obtain justice. And so ultimately, for me, there are many parts to this amendment. The first part is the attorney's fee provision. The second part is the damage caps provision. And the third part is the rulemaking authority provision. And I believe that all of those, if you look at this as a whole, are designed to hurt the everyday Arkansan and to help protect, again, the rich, the powerful, those who have influence at the Capitol. And I just think that it is a terrible piece of legislation for those reasons. Ultimately, I believe that we have an obligation, we have a moral obligation in this country and in our state to look out for the least among us. As the Bible says, as you have done to the least of these, you have done also to me. And we have to look out for those who have been severely injured or killed, those who are in nursing homes, who have no voice of their own, who may not have a lobbyist at the Capitol. They don't have political action committees who are contributing money to people's campaigns, looking out for them. I'm talking about people who truly have no voice at the Capitol. We have to look out for those folks. And issue 1, if passed, is going to it's going to just be devastating for those people in this state.
Thank you very much. I'm going to exercise the privilege of asking a question. Since we were unable to find someone to come who was going to defend issue 1, I told the three of them beforehand that I would play the devil's advocate, at least in the beginning, before I allow all of you to ask questions. So, the Republican Party has traditionally favored tort reform. And indeed, the governor, when he was in Fayetteville yesterday, spoke to the Bar Association, said he was in favor of tort reform. So if tort reform is something that is favored by the party and the governor, why does this fail? And more significantly, what would be a better type of tort reform that the legislature should adopt?
Yes, I'll go, because I'm always the one that opens my mouth and nobody else wants to. Rebecca over there's laughing, she knows I do. First of all, I've never been accused of 100% agreeing with the Republican Party, even though I'm a Republican. There are areas where I diverge, and I think that that is important. I think that you are supposed to subscribe to a party that you are most affiliated with, but you are not a drone for that party. You're not a robot for them. When you get elected, you are not elected by the party. You are elected by the people. The party just helps delineate where your leans are. I mean, there are conservative Democrats, there's more liberal Republicans, everybody falls on the spectrum. It just kind of gives you a guideline, in my opinion. I think that when people elect folks to go to the legislature, they elect them to represent them, not the party. And I will never be accused of voting party line. But I am conservative. So those two things don't always align. You would think they would, but they don't. And this is one of the instances where I can make the argument that it does not. Issue 1 is arguably tort reform. However, there are very good conservative reasons to be against it, as have already been stated up here already. So I would say that most of the people that I've spoken to within the Republican Party that favor tort reform, or say they do, have no idea what they're talking about. They truly don't. You say, I favor tort reform, and you say, okay, well, what do you favor? Well, okay, tort's a very big word. I mean, it means a lot of things. It's all encompassing. It's like saying, you know, I want ethics reform. Well, what specifically are you after? It's a broad topic. It can mean a lot of different things. So the average everyday Republican, I would say, and these would be the more informed, really don't understand what it means. They think frivolous lawsuits, we've got to stop them, tort reform. And it really goes no further than that. And so as a Republican, I don't support this, but I still maintain I'm a Republican.
Increased penalties for attorneys that file frivolous lawsuits, or that strongly penalize attorneys who were caught taking advantage of their clients or spending their escrow money, or, wronging them. I'm all for doing things that would genuinely help reduce frivolous lawsuits or predatory behavior by any trade or any profession. But this tort reform in issue 1 is really a bait and switch. And part of the problem is you have to go back to the premise, which is Arkansas doesn't really have a lawsuit problem. We have the most conservative jury system in the entire country. Hold on to your seat that the average jury award in Arkansas is, brace yourself for these runaway Arkansans. They're wild. $3,000. Yes, $3,558. Okay? It's crazy. 0.05% of Arkansas jury awards are over $1 million. 0.05%, not even 1%. And so actually, I would agree with the members on party. I was my company's political director. I've been a delegate to multiple Republican national conventions. I agree we want less regulations. We do not want any trade or profession to take advantage of people. But that's all cover for this bill, because this bill isn't really about frivolous lawsuits at all. It doesn't try to penalize bad actors. This bill is about doing a favor for an influential, powerful special interest that wanted this bill passed. And the reason that so many Republicans have went silent on it is because the polling has started showing them, oops, nobody in my district agrees with this bill.
Well, I'm going to disagree with Chad in one respect. He said because there was one special interest, powerful special interest that wanted this bill. There wasn't actually one.
True.
There was actually many special interests who are behind this bill. And so the question, I think, is about if the Republican Party supports it, and you're a member of the Republican Party, how do you not support it? And do you, generally as a member of the Republican Party, support tort reform? If you define tort reform as more broadly as judicial reform, as in penalizing attorneys who file truly frivolous lawsuits, I think that's something that we should do. I think there's mechanisms available in the law already to do that. Under Rule 11 sanctions, a judge already has the ability to sanction an attorney who files a truly frivolous lawsuit. And to Chad's point about, what is this really about? If this bill were truly designed to stop frivolous lawsuits, it's curious that it doesn't even have the word frivolous in the body of the text. You can't even find the word frivolous in it because it's not truly about frivolous lawsuits. And so if you define tort reform that way, about penalizing attorneys who file frivolous lawsuits, I'm for it. I don't think that's what this proposed constitutional amendment does. Secondly, as Chad said, if you're talking about attorneys who take advantage of their clients, who charge exorbitant contingency fees, 50-60% of the settlement, that absolutely should never happen. Never is not a good word. That I can't imagine a scenario where that would be probably necessary. But, if you're talking about limits on contingency fees, I don't really have a problem with that per se. I have a problem with how they try to do it in this issue. They want to make a limit on a contingency fee on the net recovery, not the gross recovery. And again, that's designed to make it where a lawyer can't make any money on a case. If a lawyer can't make any money on a case, they won't take the case. And if they don't take the case, then the case never gets brought, which means those who may have offended someone in this state will never be held accountable. And that ultimately is the goal. And so I'm not opposed to caps on contingency fees and making attorney's fees to be reasonable. I'm opposed to how they do it in this bill. I am adamantly opposed to caps on a human life when someone dies as a result of negligence. And I think that's where the pro-life argument comes into play here and becomes very relevant. But again, back to your question, and how do you square being a Republican and opposing this bill? Let me just say this. I don't really think this is a Republican or Democrat issue. If you look back at the history of the legislature, the Democrats were in control of the state for many years, and they passed some tort reform back in, quote-unquote, tort reform back in 2001, 2003, different years, I think 2003. There have been various measures. That was a democratically controlled legislature. So, if you look at the legislature and you say it's the swamp, I think it is. It's just the alligators have changed from blue to red. And it's the same special interest pushing the same old thing, and it's not a Democrat or Republican issue. It's, and so, I'm opposed to it on moral grounds, and to me, I don't think it has a lot to do with Republican or Democrat.
Well, I might add this to Representative Gasaway's point, nearly moved you to the other end of the building. Add to Representative Gasaway's point too about the party being in control of tort reform. The Democrats, who are generally supposed to be opposed to tort reform, they passed it in 2003. And he's exactly right. I mean, what you see changed is the party affiliation of the General Assembly, the majority of the members of the General Assembly. But what did not change is the exact same special interest. It's the exact same good old boys club that hang out in the hallways of the Capitol that were pushing this then, that were pushing it now. Some of the wait staff that carries their water for them have changed from, as Jimmy said, from blue jackets to red jackets. But the same powers that be are still there. And which is back to something both of you said earlier about why it's so important that we keep the integrity of the court, because it affects people's real lives and justice, and we keep that separate from the political influences of legislative sessions.
All right, let me turn out to the audience. Who has a question they'd like to ask? Go ahead.
For anybody, I'd like for you guys to talk a little bit about the process that went on down there. We're talking about the swamp. We're talking about, people pushing each other's buttons and things down there. Give us a little bit, as much as you can, of the inside information about how that process came to be. How does SJRA become issue?
Why is it always me?
Two of you were there.
He got much more involved with it in the House than I did. But I didn't know anything. I'll just speak from my perspective. I can't speak from anyone else's. I'm one of 100 in the House, so I can just tell you what I saw. That's the only fair thing that I can say. I know that when this bill was filed, I had never heard of it, which is interesting because it's a huge deal. I mean, a constitutional amendment you typically hear about well in advance, especially in your caucus meetings beforehand. You usually don't find out about things on the House floor, or once it's been filed in committee, or some lobbyist calling up saying, hey, did you see this huge thing that was filed and your name's not on it? So that was really unusual for me from the outset, that this hadn't been discussed, especially it's a Republican thing, as you were saying. And that should tell you right now, it is not a Republican thing, or it would have been talked about in the Republican caucus. Now, maybe I missed that meeting. I don't think I did, but it's possible. I never heard of it. But when it was filed, if I recall correctly, it had plenty of co-sponsors in the House and Senate already on it, and I never heard a word about it. So I think that the powers that were behind this were very careful about who they approached to co-sponsor this. There have been several House members that have later said they didn't truly understand what was in it, which happens sometimes. There's a lot of things that are filed, and you do trust the people that talk to you. There are some that are very upset about that now, that they were not told exactly what was in it. But I have seen multiple times where somebody will come up and say, I don't have a bill with me, but this is what it does. You're in agreement, right? I mean, you're Republican or you're conservative, or you know, whatever the twist is on it. You support this idea, correct? Yes, we'll co-sponsor it. Okay, you co-sponsor it. So that's a trap. You don't usually find that out until after your freshman session. You usually have to make that mistake before you figure out that that's a trap. Because what happens is once you become a co-sponsor on something, then you actually read the bill and say, I don't support this. The details, I don't support what this does. It's really difficult to get your name back off of it. And there's a tremendous amount of pressure for you to stick with what you've already agreed to. I think everybody makes that mistake one time, and then they don't make that mistake anymore. But you have to remember, we had, what, 40 freshmen, I think, 40 freshmen in the House, not that you did it, but 40 freshmen in the House that came in and can make that mistake very easily. A lot of pressure to sign on to that thing. It started in the Senate, then it came over to the House. It seemed like the members of the Senate got on that committee just to pass this bill. I've never seen the red carpet rolled out like this thing did. Very, very favored. It just sailed through. It really did. So it was just really different the way that this happened. It felt very orchestrated all the way through. And I just felt like an onlooker because I'm not known for being a tort reform advocate, so I wasn't approached at the beginning. I didn't find out about it until the end. I was requested to not speak against it, but I don't think that mattered. Jimmy spoke against it, and they did far better than I ever would have done anyway, so it was different the way this rolled through, but I think it's very indicative of the fact that this came from special interest. It did not come from the party. This is not a party issue, and I think that's why you see so many Republicans either before the bill was passed, voting or speaking against it, and then afterwards, after some figured out they kind of had been hoodwinked in a certain sense. They've either stopped advocating for it or have come out specifically and said, look, I wasn't told what this really does. So I think that indicates this isn't really a party thing. This is a special interest thing. And that was my view, from my seat in the House.
Representative Gaspar.
As far as the process goes, I can't really recall if this originated, I guess it originated in the Senate. It's SJRA, it was SJRA, Senate Joint Resolution 8. So it was originally filed in the Senate. I didn't really see all of the proceedings as they went on in the Senate. I do know that there was maybe a concurrent resolution filed in the House that mirrored this one, and that was in the State Agencies Committee. I think the chairman of the State Agencies Committee was Representative Ballinger, who was the lead sponsor in the House on the bill. And so, it helps to be the chairman of the committee where the bill is going to be heard. And so the bill, came to the House State Agencies Committee, as I recall. There were several bills, by the way, all the constitutional amendments. And there were, I can't remember how many, but several proposed constitutional amendments that were filed, well in excess of 10, I know, that were filed, and all of those go to the State Agencies Committee. Okay, that's where they have to go there. And I think there was a special rule that was kind of made this session, the past session, that all of the constitutional amendments, before they would be considered by the full state agencies committee, was going to be vetted through this subcommittee of the state agencies committee. Now, what's interesting about that is I was a freshman in the House, and when the Speaker announced the appointments to various committees, I was on the Judiciary Committee, or I made it to the Judiciary Committee in the House, but then the Speaker named the chairs, the vice chairs, the subcommittees, the chairman of the subcommittees, and so on and so forth. And I was named the vice chairman of the Civil Law and Courts Subcommittee of the Judiciary Committee. And I thought, wow, what an honor. I'm a freshman. I've been named the vice chairman of the Civil Law and Courts Subcommittee. And Clark Tucker was named the chairman of that committee. And so I went to Clark and I said, so when are we going to have meetings? And he was like, oh, you don't get it. He said, these subcommittees never meet. Which I thought was interesting when all of the proposed constitutional amendments were sent to this subcommittee on constitutional amendments to determine only 4 that would be able to come out of the subcommittee to be considered by the full committee. And so I had filed, along I think with Senator Brian King, and he was the Senate sponsor, an alternative proposed constitutional amendment for tort reform. Well, that never made it out of the subcommittee for consideration by the full committee. SJRA, or the House version or whatever, that came out of the subcommittee to be considered by the full committee. At the full committee, the Chief Justice of the Arkansas Supreme Court, which who are we going to respect any more in the state than the Chief Justice of the Arkansas Supreme Court, came to the State Agencies Committee and testified against the bill. And his testimony to me seemed to fall on deaf ears. I spoke against it, trying to recall who else. Rose Mims from Right to Life, Arkansas Right to Life. And she was there. I can't recall if she actually spoke against it, but there were several interested folks who spoke against it, including the Chief Justice. It passed out of that committee, and as I recall, there was kind of a special meeting that was called late in the afternoon upon adjournment, which those meetings can be called by the chair. So Representative Ballinger called a special meeting upon adjournment of the House session of state agencies, and that was going to be considered. And talking about, as I recall, I don't recall receiving a lot of notice that was going to be on the agenda for the committee. But everybody showed up, there was testimony for and against. It passed out of that committee and was put on the calendar to be voted on in the House the very next day. Well, I pulled the rule book out that night, and you can't do that. The bill has to sit on the calendar for so many days before it can be, after it passes out of committee, if it passes after like 4 o'clock, before it can be heard the next day. So the very next morning, the very first thing I do is I send a text to the Speaker and I say, I'm objecting to this bill being considered today by the House. Please note my objection. And so then I get a call, I'm like, you need to come to the parliamentarian's office and we need to talk. And so I showed up at the parliamentarian's office and it was like, we're impressed. They're like, you're right. We can't do this today. But I was prepared because I knew that with a motion to suspend the rules, you can do anything. Once the rules are suspended, then everything's fair game. And so I was still kind of operating under the assumption at that point that the bill would not be considered. There were kind of statements made like, well, congratulations, I guess this will be delayed over the weekend, and now because of you, everybody will have to, think about this all weekend. And I thought, well, we'll see. Well, when I saw one of the representatives stand up and make a motion to suspend the rules, I knew what was happening. And so it was going to be heard on the House floor that day. But in preparation for that, I had prepared an amendment to that bill that I thought made it better. It's not exactly what I would have wanted, but in the spirit of compromise, I prepared something that I thought would be better for the people if it passed. And then that amendment ultimately, my amendment was rejected, and that bill passed through the House that day. And so you ask kind of the process, well, there's the process.
That's
All right, thank you.
Wow.
All right, another question?
What was my question?
Yes.
How often does that happen, the suspension of the rules?
It typically happens towards the end of session or during special sessions. It happens during special sessions because you generally don't have a special session unless you have a majority in agreement to pass whatever it is that you're going in to speak about. Because if the governor doesn't have agreement on it, then he's not going to mess with calling a special session. So it works that way. We suspend the rules so we can get in and out in 3 days because it's expected, whatever it is we're going into a special session to discuss is expected to pass. And the rules regularly require that things sit on the calendar for a certain period of time, but if we left all those in place, that special session would take many more days and that costs the taxpayers a lot more money. And special sessions generally have notice out to the public and to us. We have to get notice of what's coming up too. So that kind of serves as the public notice, but that doesn't mean we can't change our minds once we get in there. But that's usually why it occurs with special. During the regular session, it usually happens towards the end of session. And again, it's a time constraint. And I think that that's why this bill was run when it was run, is once the rules had been suspended, because the rest of us had no idea that it would have that effect. Because when you pass suspension of the rules as a standard operating procedure towards the end of session, it's just so you can get done. Because if everything has to stay on the calendar that entire period of time, well, great, we'll be here another couple of weeks beyond what we need to. So that's typically why we do it, but this was run, again, this was orchestrated. Things don't flow this perfectly. This was run after that, because the shorter the time period that we had to consider it, the less opposition can be lodged to us. And that's why they didn't want it to go over the weekend as well, is because you can hear from a lot of people on Saturday and Sunday, and you can walk in on Monday saying, oh, I'm not quite so sure I want to vote for this. Maybe this doesn't say what I think it says. And I've got, in the defense of legislators, we're accused of not reading the bills or whatever. I can tell you there's been bills that I've read, and I knew nothing more about them after I read them than I did before. Because it's on a topic that I don't know anything about, it's verbiage I don't understand, it's about an industry I'm not part of. There have been several times that I have read the language, or the context is missing, because it only shows you what it's changing. Well, sometimes that little snippet doesn't really tell you what it does. So you are very dependent upon the sponsor. You're very dependent on others to say, well, what exactly is this doing? Because you can't go research every single one of them. There's thousands of bills. So practically speaking, I do read all the bills, but I can tell you honestly, I've not understood every single one. But of course you can ask questions, but that makes you very dependent on others to give you information. And sometimes the information that you get is not correct. Either intentionally, not usually intentionally, it's usually unintentionally, especially if it's another lawmaker. I don't think I've ever been lied to by another lawmaker. Now, I have been given incorrect information from another lawmaker, but that's because they got it incorrect. But I've never, because if I had one lie to me, I certainly would never trust him again. So I've never had that happen, but that doesn't mean misinformation doesn't occur. But that's usually why rules are suspended, is usually for time constraints. Usually. Not always, but usually.
Go ahead.
As legislators, can you elaborate on your feelings regarding the last paragraph of this amendment that removes the rule of law and judgment from the courts and the juries and puts it in the hands of the legislators?
I would say I was against it. I don't know about, I'd have to go and read the exact all over again to know exactly which paragraph you're referring to. I don't know.
It's at the very end.
I wish it were up there.
So again, it goes to balance of power. Here's something that I think is very important in this, and just to truly understand the importance of rules. To give one branch of government the ability to write the rules for another branch of government gives that branch total control over the other one. It does. Practically speaking, it does. And here's something that's even more disturbing. So here we are talking about giving the legislative branch the power over the judicial, right? Because if we write the rules for it, I mean, he's already told you what happens when the rules are suspended, what happens when the rules change. What happens when people that are in control can change the rules? All kinds of things can get through that maybe the majority didn't want to get through or might have thought through better, but you can do a lot of things via the rules. You can do pretty much anything you want to by manipulating the rules. So a concern that I have with this is kind of a vicarious, just to add a layer onto this that I'm going to guess nobody in this room's probably really thought about unless I've specifically talked to you about it. But one of the other things, just to make it interesting, because I know a lot of you already know a lot about this issue, so I'm going to add a layer onto this to just make you even more fearful of it. One of the things that the legislature did in this last session was we changed our own rules at the beginning of session. I think before a lot of people really understood what the ramifications would be of this. It's a great time to change the rules when people haven't read the current set yet. And the rules were changed so that the Speaker of the House appoints everybody.
I hated that.
Prior sessions and prior speakers, actually, the members picked their own committees based on seniority. They picked their own chairs. It was very member-driven. And we've changed the rules now to where I, as an individual legislator, the only thing I currently control is my button at my seat. I don't control what committees I get on anymore. I have to go ask somebody for that. I have to ask. That's deferring my power as a legislator was elected by the 30,000 that I was elected by and gives it to another person. So let's take this a step further. So if you have one person essentially having total power over the entire legislature, and the legislature has power over the judicial branch, essentially, you have now vested all of this power in one person. That is never a good move. Now, will Matthew Shepard abuse it? No, I don't think he will. But who comes after Matthew Shepard? And who comes after him? Because we have a history of non-benevolent speakers, those who have been elected via coercion, not by popular demand. There's two different ways to get into the speaker's position. There really is. So just because we have somebody in right now that is ethical does not mean that the next person will be, or the person after that. And you have now given that person and all the special interest who has a vested interest in changing the rules for the judicial branch pretty much total control over it. And by the way, just as a caveat to that, the only way to undo our rule change that we made is to do so through the House Rules Committee. And who completely controls the House Rules Committee? The very person that has all the power. So you can understand how it's kind of a one-way street. So just to add a layer on that you probably didn't know or didn't think about is it's not just transferring power, it is concentrating power in one position, a very political position, and I just think that is a recipe for disaster for the state of Arkansas.
I would, thank you. With respect to the rules, I think there's a lot to be said there, and it's one of the harder pieces to understand for members of the general public who aren't familiar with exactly how the judiciary works and how important the rules are. If you're bringing a lawsuit, once you get in a lawsuit, when you're in court, the kinds of evidence that become admissible in court, what you can access during discovery. You know, if you're not a lawyer and you don't work in the judicial system all the time, you're not real familiar with that. And so, you know, the damage caps is something that, you know, is easily understandable. If somebody loses their life, if somebody becomes a quadriplegic or a paraplegic or severely burned and scarred and disfigured, $500,000 in non-economic damages is simply not sufficient, and most people can see that pretty easily, I think. The attorney's fee provision, most people are going to be for that because most people don't like lawyers until they need one. It's kind of like that meme that's, you know, goes around on Facebook. It's like next time you want to tell lawyer jokes, next time you're in jail, call a comedian. You know, well, it's the same thing. Nobody likes lawyers until they need one. And so, you know, people understand the attorney's fee provision. They understand, I believe, the non-economic or the damage caps provision and the implications that can have, but they don't fully understand the implications of what it means if the legislature has the ability to make the rules for the court. And I think that, in some ways, it can be the most dangerous part of this amendment, because what we're talking about here, so the rules of evidence, for example, what's admissible in court. You have complicated rules about things like hearsay and who can testify to what. Most legislators don't understand those rules. A lot of lawyers have to do a lot of research and struggle with those rules. But if the legislature can change them, and the makeup of the legislature, and everybody thinks the legislature is made up of attorneys. It's not. I think there are 6 or 7 lawyers in the House out of 100, and there's 4 or 5 maybe in the Senate out of 35. I mean, out of the entire, 135 members of the General Assembly, I don't think more than 15 are probably lawyers, somewhere in that area. So, if you're talking about changing rules for how the court operates and the kinds of evidence that can be admissible, that's a very dangerous power to give the legislature. And then, specifically, the rules of evidence and procedure include things like discovery. And that's a very important part of a lawsuit where you're trying to access information from the other side to figure out whether you've got a claim, how bad their conduct was. Well, this would give the legislature the power to control the rules for discovery, which means a party, and if they make those rules, how I predict they might, it would prohibit maybe disclosure of certain kinds of evidence that would be, essential to a person being able to make a case. And if you don't have access to that evidence, you won't have a case. And it'll just take one little change to the rules to do that. And people don't understand how important this rulemaking provision is. And from just a constitutional perspective, to go back to Jana's point, it truly is a separation of powers issue. We have 3 branches of government: executive, legislative, and judicial. The legislative branch, for example, has its own our own separate branch of government, and we write the rules for how we function.
Right.
And the judiciary is the same way. They're a separate and co-equal branch of government, and they should write the rules for how they function. And, there would be weeping, wailing, and gnashing of teeth in the House of Representatives if the Supreme Court or the judges came to the legislature and said, well, we're really lawyers, and we really know how this works a lot better than you do. We're going to write your rules for you, because you guys really aren't skilled in rulemaking. The legislature would have a fit if they tried to do that. But yet the legislature wants the power to write the rules for the judiciary. And that is truly a separation of powers issue.
I want to turn back to damages for a moment. And let me describe an ad that I've seen on television. And I'm going to ask you how you would respond to it. I'll start with you, Mr. Gallagher. So the ad is something like this. There is a very distinguished doctor standing in his office, and his name is underneath him. It clearly says Dr. MD, and it says something like this: we have a shortage of doctors in Arkansas. We need more doctors. Doctors are reluctant to come here because of our legal system, and this amendment will help encourage doctors to stay here, and it will improve health care in the state of Arkansas. So when you see an ad like that, how do you respond to that? What would you say to people of Arkansas about that ad?
Sure. I'm going to take 1 minute of liberty and say one thing about the rules.
Go ahead.
Because I just want to show behind, these folks are being constitutional scholars about this. Let me just tell you, let me tell you the behind the scenes, what it really means, okay? Because in 2003, I was the political director for Governor Huckabee's office when tort reform was first proposed. 2 bills were proposed. The bill that was known by slang in the capital as the nursing home bill, because that was the industry pushing it the hardest. No one has contributed more to legislative campaigns. No one has spent more on lobbying. No one else has yet been discovered recently for bribing and wire transferring money to legislators. And so when you say, well, why do they want to move the rules? Some people say, well, the judiciary is out of control. Listen, as a conservative, sometimes I think that. that I think there are judges that legislate from the bench, and it offends me, and I think that we need to do things about it. This doesn't do that, though. The rulemaking in 2003, the Nursing Home Tort Reform Bill that did not pass, okay, that was the version that was rejected. It included, and anybody can get a copy of the bill, it included the following proposed rules, okay? It included rules that they would have adopted in their legislation that would have made it much easier for nursing home patients to waive their right to a jury trial. It would have prohibited employees of a nursing home to testify as an expert witness without the permission of the nursing home owner they work for. It would give immunity to all nursing home directors for any abuse or civil cases. It would prohibit the following things as evidence in the court of law: state inspection reports of nursing homes, government investigation reports, references to other patients at the facility, even if they were harmed or died for the exact same cause. So you want to tell me that there's not some folks sitting out there waiting to get to make the rules? The real reason why rulemaking is an issue 1 is because there are special interests right now. It's not because legislators want to punish the judicial. It's because the special interests pulling the string, they already have their rules drafted, and they want to start pushing them through. Now, that aside, I'll try to be quick to answer this question, because it is the most compelling argument to the other side, from the other side, is issue 1 passed will help healthcare in Arkansas. Well, we all want better healthcare. But you know, when you stop and think about it, there are some realities that we have to look at and consider. Arkansas has 3 million people. Most major medical centers are in urban areas. They have a concentration of 3+ million people. It's like Dallas, Houston, places like that are major medical centers. We're never going to have some of the medical specialties that a city of 3 to 5 million people can have. And I would speak directly to this whole issue about losing rural doctors and affecting rural healthcare, and really just say that I think it's a bait and switch, honestly. Because if you look at the map, we're the only state out of every state around us, including those that have Tort, we're the only state that has not lost a rural hospital to closure in the last 8 years.
Wow.
Every other state around us has lost rural hospitals. We have not. The loss rate of rural doctors, there is not a 1% deviation between Tort states and non-Tort states. Matter of fact, in Oregon, they have a program that provided 80% subsidy in malpractice premiums for rural doctors and 60% subsidy for family practitioners. And the rate of stop service for physicians who received the subsidy and physicians that didn't in rural areas was exactly the same. This generation of Arkansans and Americans coming out of med school, there's a massive, it crosses all professions, there's a massive movement to urban areas. I'm a rural Arkansas boy, and rural Arkansas and rural America, they're losing doctors, they're losing engineers, they're losing architects. We have counties in Arkansas that do not have attorneys now. Attorneys that could go into those counties to do their ad litem and their various work. And there's a lot of reasons for that. And I'll wrap it with saying this. I was, as the mayor of a small town, and I was on the hospital board in that small town. And I love our rural hospital. Rural America has problems. And there's a lot of things we've got to do to rescue it, to reinvent it. The problem's not Tort. In all my years, I did at least 50 doctor recruitment dinners and lunches. In all my years, I never had a single doctor say to me, well, Mayor, I'm going to explain this to you. I'm intending to come to the Queen because of the nightlife. The vast number of restaurants, the sporting venues, the theater and the entertainment options and the hockey games and the rodeos and you know, I've had my head down in med school and I've been exhausted and I'm finally able to focus on the social life. I'm definitely coming to the Queen for the social life aspect. But you know what's going to keep me from coming here? Tort. It's Tort. Instead, I'm going to move over to Podunk, Oklahoma, because they have all those things. No, that same state that has Tort their rural communities actually have less rural doctors than we do. The problem with healthcare in Arkansas has nothing to do with tort. There are a lot of challenges that we've got to overcome, but that simply isn't one of them.
Anyone else want to comment on that to add?
I think he handled that one.
Another question? Yes.
So our Constitution was passed in 1874 and had a specific provision that said that the legislature cannot limit damages in injury cases or in wrongful death cases. That's 144 years ago. In Arkansas, in the last couple of years, in my home state, in my hometown, we've got a legislator, Jake Files, under investigation, along with David Norsworthy, nursing home owner, for an $80,000 secret prior transfer, which was given to Files about a week after tort reform was introduced in 2015. We had the same nursing home owner's partner and majority owner of the nursing home who gave a bribe to Michael Maggio, circuit judge, at the same time the circuit judge was lowering Morton's nursing home verdict from $5.2 million to $1 million. My question for you is a couple of questions. Number one, do you think that when we're changing 144 years of constitutional history that I've just referred to, Article 5, Section 32, do you think the people should have been given in the 2017 session more than a total of 30 minutes in both houses to testify? Rose Mims did not get to testify as to her position against this. And secondly, what impact do you think corruption and money influence had on issue 1? And it's coming out of the legislature.
Well, I'll say this quickly and then turn it over to the legislators. I'll say that personally, I think that even though they're not required to by the Constitution, I think that it would be responsible behavior by our legislators to say that if we're going to amend the Constitution, that there should be a long, deliberate effort of public education. I'd love to see the legislature say, look, it's not required of us to do this, but if we're going to propose to amend the Constitution, we're going to hold hearings across the state about it. We're going to very deliberately make sure that everybody wants to be heard, because it's a big deal to amend the Constitution. And so I'd like to see that. I'll say this: they're genuinely speaking to the corruption issue. They're genuinely is a fantastic group of people who work in the Capitol that I believe truly love their communities and love their state, and every day are trying to serve the betterment of the state. However, there's also corruption, and which is all the more reason that I think it's important that we don't move the rulemaking now, that for evidence and for these things that we're talking about, to the place that's the most susceptible to lobbying and to special interests, which is the legislative branch.
Other comments?
I'll speak to the public comment period. I've found that disturbing in several committees that I've been on, not just, I don't think it should be the case just for constitutional amendments. I think it should be the case overall. For example, I was in, this is my first year to be on the education committee, so it's my first year to go through the adequacy work that we have to do every single year to make sure we stay in compliance with the Lakeview decision. And I just remember reading through this huge report of information, and I'm flipping through it, and there's the public comment section. And I'm looking through it, and it's purely organizations listed there with their viewpoints, the AEA, the AAEA, Forward Arkansas, et cetera, all good organizations want their point of view, that's great. But it said public comment. This isn't public comment, this is lobbyist comment, this is association comment. That's not what this is. And so it irritated me, and so I made a motion that we should actually get public comment. And I got a little bit of pushback on that. They did agree to do it, but it again, time constraints. We only have so much time, we only have so much time. And I think that we get too caught up in trying to be efficient and hurry the business along. Because if we sit around too long, well, they're just trying to get more money because, they get paid for going to these committee meetings. So it's a double-edged sword. But I think that we do need to do a better job, especially on the more important issues. Adequacy is a huge issue, and there are a lot of people in the state that I know have a lot of opinions about that. We ended up putting it on the website. We ended up getting 109 comments in just a few days, and that was just from the few folks that even knew about it. I don't know what kind of input we would have gotten if we would have actually gone around asking these kinds of things. So yes, I think we can do a much better job, but I think on the flip side of that, the people have to allow us to do that and understand if we do take 3 days for a committee meeting, well, it's because we were listening to people. And that happens during session too. Especially during education, it probably happens during all the committees, but I noticed a lot in education doesn't happen in the city, county, local all that much. We just don't have that many people. But in education, you end up having so many bills you need to review and so many people that want to talk about them, and they end up being redundant. And I'm against it too, and I'm against it too. So you get to the point that you go, you know what, everybody that's against it out here, just raise your hands. We have done that. Okay, lodged. Totally get that there's 58 people in this room that are against this. So there's that. But again, I think it just comes down to efficiency. I don't think that there's anybody in the legislature specifically that's trying to deny the public the ability to speak. Sometimes there might be sponsors, that don't necessarily want that. But I don't think as the body as a whole is trying to do that. I think we just get caught up in, kind of like with legal system, sometimes people don't get justice all that well because you get too caught up in trying to move the cases along. You're trying to process, you're trying to get everything through. So, but I think we should do a better job of that, especially in constitutional amendments. I agree.
Briefly, the provision that you mentioned, 1874, is that correct? Yeah, absolutely. I think we should be very hesitant about moving the old landmark and things like that are in our Constitution that have been there for so long, that were placed there by the wisdom of those who drafted our Constitution, just like we have provisions in our federal Constitution. We should be very careful before we start amending and making changes to those. And there's a reason why they put that in there about no limitations on damages in civil cases. And it's, that's something that stood the test of time because there's wisdom in that. And so that's one of the objections that I had, absolutely, as SJR 8 made its way through the legislative process, was that we're talking about amending our Constitution here. And we should, really be more deliberate about that, and not be so rash to just pass something that's going to make, just a landmark change in how our judicial system works and in our society. And so, absolutely, I agree there. One of the interesting things, and I don't know how this would speak to your other question, but I'll just say this. The legislature can refer out 3 constitutional amendments that can be referred out by the legislature. One from the Senate, is my understanding. One from the Senate, one from the House.
Those are recent rules. Those weren't the rules in the last session.
Okay.
New rules. See how it changes everything?
3 from the General Assembly. Okay, where they come from?
Senate referred out as SJR 8.
May have changed, but my understanding is there could be 3 proposed constitutional amendments referred from the General Assembly. And one was SJR 8, the tort reform. The other was voter ID, is that correct? And there was a third that was proposed that we thought was going to come out that would have made it much harder in the future to amend the Constitution. Now, I find, again, read into it whatever you will, or out of it whatever you will, but, if that ultimately didn't come out, I don't know why, but I'll just say that if SJR 8 came out and it passed as issue 1, and voter ID, don't know what will happen with it. I personally expect that it will pass. And the other one would have been to make it much harder to ever amend the Constitution again once they got in what they wanted. Now it would make it almost impossible to change it. Now, that didn't happen. But I think that we really need to look at how we handle constitutional amendments in Arkansas, whether that's referendum from the legislature or initiatives from the people, because I think we're on Amendment 94 or 95 in the state constitution right now. You know, at some point you say, do we have a constitution or do we have 95 amendments? It becomes ridiculous at some point. And so I think those are all things to keep in mind as we move forward.
I teach a course on the Arkansas Constitution. And at one point, our constitutional amendments were one sentence long. So we have a constitutional amendment that says the General Assembly shall not pass any special or local legislation. We have another constitutional amendment that says the Supreme Court has power over lawyers and the practice of law. Today, our constitutional amendments are incredibly long, complex, and they have provisions that need to be in statutes. And for instance, it would be much easier if we had an initiated amendment that said the General Assembly has the power to create 4 casinos. Go to work. But instead, we get a long, complex provision. I want to say one thing about the rulemaking power. Currently, the Constitution provides, the current Constitution, that the legislature, by a 2/3 vote, can amend or annul rules of the Supreme Court. So when I was at the Supreme Court and I was involved in rulemaking, I learned on the inside how this works. So for instance, when we need rules for civil courts, civil litigation, there is a committee called the Civil Practice Rules Committee. The Supreme Court appoints 20 members to that. We work very hard to find 10 that are plaintiff lawyers and 10 that are defense lawyers. We work very hard to find some from big firms, small firms, from Little Rock, from Paragould. We want a diversity. Those 20 people meet with 2 other individuals, a law professor and a member of the Supreme Court. And those 20 people come up with suggested rules. When they come up with the rules, they come to the Supreme Court. We sit around and we look at those rules and we say, do these look like good rules? Sometimes we say no, we send them back to the committee. If we like them, we send them out to the public. And we say, you got 6 months, tell us what you think. And we get letters. And sometimes they come, we can tell they're coming from the defense bar, sometimes they're coming from the plaintiff's bar. And then we revise those rules. Sometimes we kill them, sometimes we revise them. It is a long, involved, fair process to adopt these rules. We do the same thing on the criminal side. And I'm putting aside my moderator role here. As you've said, the danger is that you're going to have some legislator who hears from some constituent who's unhappy about some case, and we need to change the rules. And although the legislature now can amend rules by a 2/3 vote, this would allow the legislature to create rules from scratch by a 3/5 vote. So it makes it easier for the legislature to get involved on the spur of the moment with hearings, with the rules suspended perhaps. All right, a couple more questions before we finish here. And we got tort reform, frivolous lawsuits. He talked about a number of those things. His opponent, Paul Danielson, former Justice of the Arkansas Supreme Court, said, judges have the power now to deal with some of these things. A judge can say, these damages are outrageous. We need to lower the damages. Right now, a judge has the power to say, this is a frivolous lawsuit. I'm going to punish you for filing a frivolous lawsuit. And so I think the proponents would say there are abuses in our current system, and it's harming our economy and harming our medical system. The response is there's no evidence of that. There's no evidence of that, and there already are powers to deal with the occasional, rare abuse.
Well, we have the best economy today that we've had in the history of Arkansas. We have the lowest unemployment rate. than we've ever had. We have more med schools today than we've ever had. We have the fastest, best growing medical community that we've ever had. We have the fastest growing medical per capita income than we've had in our history, and better than all the other southern states that are of similar socioeconomics as us. And so it's the arguments that's hurting our economy are quite a stretch. I know that's not the question, but I wanted to emphasize that.
When the governor spoke yesterday in Bayville, the governor talked about the strength of the economy. The governor said that he had not, I think this is right, some of you were there, he had not taken a stand on issue 1. He talked about the importance of the separation of powers. He also talked about believing in tort reform, and he seemed to say that sometime before the election he was going to take a stand. The governor, well, a trial judge has removed this from the ballot, and the Supreme Court is probably going to decide about 10 days before the election whether it stays on the ballot or not. And if it's removed from the ballot, the governor doesn't have to take a stand.
Well, I think the reason that the governor's hedging on it, or at least my understanding of it, is because that, he ends up appointing associate justices for any that might recuse themselves from it, such as Chief Justice Dan Kemp. He already recused because he spoke against it, so therefore, he had already indicated. Oh, well, okay, multiple reasons,
Yes.
Various positions.
Yeah, I think he has appointed a special justice. I think the special justice has been named, I believe.
For Justice
For
Kemp.
Justice Kemp, and no one else is going to recuse.
But there could be others, so.
No, anyone else who would have recused immediately unless something else comes up. They all know if they've made stands or if they have relatives or anything else. Other questions? Comments? Do you have any closing statements you'd like to make that you haven't made so far?
Just appreciate you guys coming out and listening to our point of view on this. It's really nice to get good questions from an audience that really cares about an issue.
Oh, there, Alan?
I've got a question. I'm interested in this. If issue 1 does not get back on the ballot, if it does not get back on the ballot, what do you see happening in this issue, if anything, in this next legislative session? And what can we do as citizens to approach what can we do to make it known to our legislators that represent us that this is not something that we want? It is not something, if we believe that, it is not something that's good for Arkansas.
Speaking from my own perspective, I've got one of my constituents in here, I know. What I would say, what I would recall is if you wrote to me and just stated that, especially if you're on the Republican side of things. And, I am a Republican, I am part of this party. I do not support this. These are the things I don't like. I get some emails. I know that some legislators have much more active constituencies than others. Mine's not terribly active. I just don't have that many people within my district that are really engaged, and some are very engaged. So if I get a letter from someone saying, this is how I feel about this issue, it registers with me. I might not remember who they were, exactly what they said, but if it comes back up in session, well, there was somebody that said something about that. I'm going to go back and look through my email and find who that was, and I do that frequently. I forget things, but I recall just enough of it to know that it existed, and then I keep every email, so I can go right back through everything. Oh, that's who it was, and that's what they said, and okay, now I recall. Now I might email them, hey, this is coming up. What do you think about this? Especially if you're in that industry, that carries a little more weight with me too. That you're speaking from a knowledgeable perspective on it. So attorneys' perspectives, judges' perspectives, things of that nature would. Or even, industry owners, the people on the flip side of this would make an impression, but communication is all I can say. We don't know what you think about it if you don't tell us. we're not mind readers. So you have to email us, you have to call, you have to say it in some way so that we see it.
If this is removed from the ballot, it will be removed because there are 4 types of issues combined in one amendment, and that violates the Constitution. And if it's removed for that reason, then the proponents probably would say, well, we need a simpler, cleaner, one-issue bill, such as just deal with punitive damages or something. That's what the proponents, that's what someone would tell the proponents, I think.
Let me mention this to just predictive, kind of pontificating here, which is really worthless, Alan, as you know, or Hillary Clinton would be president if people predicting things meant anything. But I would say this, I think that there is, I mean, there are people who are diehard supporters of tort reform who will not give up. I mean, they'll continue. But I will say that they will be met with much more resistance and skepticism and fatigue from their colleagues. When you have almost 30 people that voted for a bill now saying that they are not actually for it, that they just wanted to get the voters the chance to vote on it, that's some significant backtracking, right? And what I think will happen is that, or at least what I hope will happen, is that recently the Talk Business poll by that Roby Brock and Harding does, very credible poll for the state, very well respected. They've been doing it for 16 years, never been wrong in election cycle, and 2 to 1 Arkansans that have made up their mind on this issue were opposed to issue 1, 2 to 1. And I don't think that's lost upon legislators who have to get elected in their districts. And so I think that it will hopefully make people more circumspect, more thoughtful, and I think that Arkansans can't, now that they've started to become educated on this, I think that they can't stop voicing their concern. They have to move this from this time on a vote November to move it to, as the representative was saying, continually voicing to their legislators, look, we're not for any of that kind of stuff. Leave the juries alone. Leave justice alone. Don't cap what damages I can get. And I think they have to just keep beating that drum. And I think it's incumbent on people like myself and Rose Mims and Jerry Cox, people that work with citizens to not lay down the banner the day after this is thrown off the ballot or the day after election day. Instead, that we continue organizing as citizens and just say, look, we have to be vigilant from now on this topic.
Just to try to keep it brief in response, what can you do to be effective, and what can everybody in this room do to be effective? Number 1 is educate yourself, which you're here tonight to do. Then educate other people. Once you know, tell somebody else. And then number 3, for the upcoming legislative session, for your legislator, you need to get to know personally your legislator. I mean, go see them. Look, in the legislative session, we get 1 million emails, and they come from every organized group all over the country on every kind of issue. After the session, get back to my apartment and I'll check my email. And I can just scroll as long as I want to scroll on emails that I got that day. They may not read your email. If they read it, it may be one of 200 emails you get that day, depending on what issue is pending before the legislature. But if you contact your legislator in person and you talk to them and you explain to them, I'm against this, and this is why I'm against this. This is not good for the people of Arkansas, and you really need to, oppose this. And I'm watching, and so are a lot of other people. We're interested in how you vote. Your legislator is going to pay attention to that, and that's on every issue. We get that on every issue, whether that's gun legislation. Get contacted by a lot of people on every different side of the gun debate. And, some of those people have contacted me personally, want to come meet with me. And I appreciate that because they're passionate about the issue and it offers me a perspective than just some cold email. There are people that will call the house and they'll leave a note that gets put on my desk along with about 50 other notes that are sitting there. Vote no on this, vote yes on this, vote no on this. And it's not that I don't read them, and it's not that I don't take them to heart because I do. But it's not as effective as an in-person visit from a constituent who cares deeply about an issue. And so, I would just encourage you to do that.
John?
I just wanted to ask Mr. Gunn, did I hear you say 30 sponsors have background?
I don't know that they were sponsors, but almost 30 members who voted for the bill have said that the reason they voted for the bill was not an expression of support of issue one. It was just referring to allow the voters an opportunity to vote on it.
Do you know where I would find confirmation of that? Backtracking? Where would I go? Or do you just know this from talking to you?
Well, I just know from us, some of it from conversations, but most of it's just from tracking that we've done either in the press or in social media, probably Facebook or Twitter.
Okay, thank you.
Yes.
And I have great respect for very many who are for this, very many legislators and senators. And I know some could have, done it knowingly, doing a horrid thing. Or they're just sold a bill of goods and they believe it. And I just hate that there's so many bills going before them. And then the skids were greased on this. They weren't in the committee. They didn't get to hear all the Supreme Court justice speaking. It's sad that so much has to go through and they are not knowledgeable. There's no way they could know everything. And I just have to go to them and say, you have been misled. I can't go this.
That's why we have elections in this
But I
country.
still respect them. I'm still gonna vote for them. Because they're
go to
good
polls to
people.
elect our representatives and vote on them.
That feels the same.
Thank you all for being here. Thank you very much.